And welcome back to the Law and Crime Network. I'm your host, Amy Dash, here with Law and Crime trial analyst Ken Belkin. And we are going to talk about really what is the central focus of the case, and that is the Stand Your Ground law in Florida. First of all, what does it stand for?
Well, look, the wonderful thing about living in a republic is that each state can comprise its own laws, and we get to sort of see what laws work best and what don't work so well.
Oh, really? You think that's what's so wonderful about living in a republic? Because I think one of the biggest problems is that we don't have uniformity.
Well, look, the thing is, different states try out different things, and we get to see what works. Now, Florida has chosen a self-defense schema of Stand Your Ground.
Right.
In that, if you are feeling an imminent threat of a threat to your life or serious bodily injury, you are privileged to use lethal force in defending yourself. Now it's a little bit different.
Though, Ken, this is different from other states where a lot of states have a
like
requirement.
Like the state we're in right now.
Yes, that you have a duty to retreat.
Yes.
First. Florida, there's no duty to retreat.
No duty to retreat.
Right.
The exception, in New York, we have something called the Castle Doctrine, where if you're in your own home and you feel that there's an imminent threat to your life or to serious bodily injury to yourself, you're then privileged to employ lethal force. But otherwise, you must retreat. You have a duty to retreat.
Except in your home.
Except in your home.
Right. So, in Florida, it's much more liberal.
There's no duty to retreat.
You can just kill people without having to do anything. So here's the thing.
You have to be able to establish that you reasonably anticipated an imminent threat to your life or to serious bodily injury to yourself.
Okay, so the issue I see here with this case is that, what does that mean, imminent threat? Because
it certainly doesn't mean in Billy Woodward's war of a case that, you go home, you put on your battle fatigues, and you go out there and crawl along your lawn and lie in wait and
pretend like you're deployed on a mission in Iraq.
Yeah. I think a much better defense in this case would have been some sort of mental health defense.
Yes,
but that's not really what we're seeing.
Well, because some of the language indicates that there was post-traumatic stress disorder, and he did serve in Iraq.
And he did perceive. He said the night he was arrested to the arresting officer that tonight it became a war and I wanted to end the war, or something to that effect.
So in the alternative, they could have come up with a defense invoking that he was experiencing post-traumatic stress disorder. Is there such a thing for that specific condition?
I don't want to Monday morning quarterback the defense attorneys in this case. But
you just
given from what I've seen, I probably would have employed an insanity defense. I would have said, look, this guy could not appreciate the difference between right and wrong when he did these actions. When he shot and killed these two victims and shot Mr. Blake 11 times, almost killing him, he didn't really understand what was wrong. He thought he was at war. And at war, these are things that you do. You shoot your enemy.
Right. Now, here's the argument that the defense is coming up with, that he thought there was an imminent threat to him and his family because they had been taunting him, they had been threatening to burn down his house, they had been threatening to rape his daughter, a lot of it caught on camera by surveillance that he set up. Yes. So the question to me is, can the imminent threat be something that has built over time, or does it have to be an imminent threat that exists at that very moment that he goes out and shoots to kill?
It's got to be imminent. It's got to be at that moment.
But what does imminent mean? I mean, that's really what this case is all about.
Imminent means directly before the event. Let's say these guys had a gun and they were like, we're going to shoot you, and they took aim, and he took aim, and he fired first and killed them. That's an imminent threat. 2 weeks ago, this guy saying on camera, I'm going to burn your house down, while probably drinking Budweisers in his carport. That's where I believe one of the victims was shot. I don't even know what a carport is.
It's like a little awning that covers the car. No, but I did look into it at one point because we were going to move and I was looking at homes without garages. If you don't have a garage, it's like a little awning.
Well, I live in Brooklyn and I don't have a garage or a carport. But the point is, it's an imminent threat. It's something that you can appreciate. It is right in the moment and you are reacting. It's almost a reaction to the threat. Not something that comes 2 weeks later or a day later or even a couple of hours later where you have time to cool off, where you had time to evade the threat. He was not under imminent threat. This guy went home, he prepared, he put on fatigues, he dressed the part, and he lied in wait on his lawn and took aim.
But is it going to be left up to the jury how much time needs to pass? What constitutes a cooling off period? Because a lot of times in these laws, it doesn't specify how much time. Is it a moment? Is it minutes? Is it hours? Do they have to do X, Y, Z before?
I'm sure that Florida defines imminent somewhere, and the jury instructions, there's going to be a definition of what imminent threat is at some point.
But then the defense attorney wouldn't come up with this type of a defense if it was so specific as to what constitutes imminent danger.
The defense attorney, you don't get to pick your cases, and this is not a great case, admittedly. This guy made multiple statements. There is no dispute that he committed these murders, and he committed the attempted murder. It's just whether or not he was operating under an imminent threat and was reacting in self-defense, which I don't really see. This guy had plenty of time to evade an imminent threat.
So then what is the culpability for people who are antagonizing somebody who might have some mental issues, or people who are making threats? Who's to say that those threats, how do you know they were not serious threats, that these people were not planning to rape the daughter or burn the house down?
I'm not saying that, I think to a certain extent the system failed Billy Woodward. He went to the police multiple times about this harassment. And certainly these threats, they would qualify, at least in New York, and I would assume so in Florida, as harassment. There are threats against him and his loved ones. It's harassing behavior. They could have been prosecuted. They could have been charged for whatever reason. The police didn't find probable cause here to make the arrest and to prosecute them. He also had pursued civil remedies. He had asked for injunctions. They were shining lights into his home, making loud noises. He had gone to the civil court. There had just been a hearing just prior to the shooting. He had asked for injunctions. The judge denied him. The criminal justice system failed him, and the civil justice system failed him. And Mr. Billy Woodward took it upon himself to enact his own form of vigilante justice.
Right, but one of the key questions is, did he act out of anger, or did he act out of fear?
Well, he wasn't acting out of love, Amy.
Right.
That's for sure.
Well, yeah, absolutely. That's ruled out. But weeks of this taunting behavior, weeks of threats against your family, serious threats that indicate that these people may have wanted to inflict harm upon him and his family, couldn't that incite fear?
It could incite fear. It very well could. And it should have been prosecuted. They probably should have been arrested, especially if he was documenting this stuff with video surveillance and audio surveillance equipment. These things were documented. The police probably should have made an arrest, but they didn't. Police have broad discretion to whether or not to effect an arrest. And in this case, for whatever reason, they didn't do it. Maybe they thought that Billy Woodward was a less than credible complainant, and they thought he was a little bit off, which, obviously he is a little bit off. He shot and killed 2 people, attempted to kill a 3rd. Police didn't do anything. And at this point, he took it upon himself. But we can't allow people to pursue their own extrajudicial remedies.
Right. So then why are these 2 attorneys volleying over the issue of, was it anger or fear that motivated him to commit these killings? Why is that relevant to the analysis?
Well, look, I think Billy Woodward's defense attorney, he's doing the best he can with a bum case. And, there have been a lot of cases, highly publicized cases, where the stand your ground defense was used successfully, such as, George Zimmerman and Trayvon Martin. But this is a different scenario. But, we can all disagree with the fact George Zimmerman should not have murdered or shot and killed Trayvon Martin. But at the end of the day, he was acting under an imminent threat, despite what your politics might be, because he was being beat up by Trayvon Martin. He had bruises. He was being attacked by Trayvon Martin.
But here's the problem, is that a lot of people say that what happened before should factor into the analysis, and a lot of times it doesn't. So if somebody is pursuing, we know George Zimmerman was the one initially pursuing. So what you have is you have a justification for somebody to employ deadly force when they're responding
after
to
being attacked.
A physical threat. But the law doesn't address that emotional torment that antagonizes somebody to physically defend themselves.
But it's got to be an objective standard, Amy.
But it can be more intense sometimes than somebody throwing the first punch. The other problem I had with that case, with the Zimmerman Trayvon Martin case, is we don't really know who threw the first punch because one of the men is dead. So they can't defend themselves. All we have is the testimony of George Zimmerman.
And look, I'm not defending George Zimmerman. Far be it from that.
No, but it exposes those flaws that we can't ever tell because the people are dead. So how do we know who threw the first punch?
But these are the flaws in the stand your ground doctrine.
Right.
Because at the end of the day, one of the parties is dead. Presumably the party who was conducting the imminent threat is deceased, and we have no record of it except for the defendant's own subjective experience. But it's got to be more of an objective standard than a subjective standard. Look, he might have felt threatened over the course of weeks, months, whatever, from the harassing and bullying conduct of the victims, but it wasn't an imminent threat at the time he committed these crimes, the 2 murders and the attempted murder.
Now, what if they had said, in the moments before he went over there, we're going to come right now and burn your house down? Would that constitute an imminent threat?
I mean, I don't know.
Do words qualify, or does somebody have to pull a gun on you?
I don't know that these words would qualify. If they started gathering gas cans and, they showed up the way we see in the movies with the pitchforks and the torches, then yeah, I think if this guy took aim and shot, he would be totally privileged under the stand your ground doctrine.
Mm-hmm. So the jury heard some of these words that he told the police. I'm a hunter, killer, I'm a soldier. This is a battlefield, and they're the enemy. And I dispatched the enemy, sir. I'm tired of living in fear. So on the one hand, you think, well, okay, he might be partly delusional, right? Because he thinks that he's in a combat zone.
I mean, Amy, if we were in Florida, sometimes I'm a little bit afraid of you. If we were in Florida and I took out a gun and shot you, said, well, that Amy Dash,
right,
she really scares the hell out of me.
And you would be justified in your fear, but not in the shooting.
Maybe in your case.
But in my case,
really,
yes. But
really do scare me sometimes.
Well, you were late today.
I know.
So I had to lay down the law.
Busy New York City lawyer. What can I say?
When he says, I'm tired of living in fear, then all of a sudden it adds a little nuance to the statement, right?
It adds a little nuance, but I don't think objectively you could look at this guy going home and preparing for battle the way he did and say he was operating under an imminent threat. I just don't see it. And I don't think the jury's going to see it, quite frankly, even though we know that Florida juries tend to really love the stand your ground doctrine.
The case opened with the survivor testifying first, shot 11 times, and he basically said, I know who did it. It was Billy Woodward. Was his testimony, do you think that's like the lock and key to this case? Or
I mean,
do you think that there's a way for the defense to even overcome that?
His testimony, the fact that Billy Woodward made statements shortly after his arrest, there's the ballistics, this case is kind of a slam dunk. The fact that it even went to trial is probably because plea negotiations broke down and, they weren't offering Billy Woodward anything so great, and he figured, hey, I'll roll the dice and take the risk at trial.
Mm-hmm. Now, prosecutors asked the judge to limit any references to post-traumatic stress disorder. Why do you think they didn't want the jury to hear that?
Well, look, if they're not pleading a mental health defense, they can't really bring it in.
No, the prosecutors.
Yeah, that's what I'm saying. If the defense is not pleading...
But he denied it. The judge denied it. So will that help, you think? Will that help the defense?
I don't know. I mean, post-traumatic stress post-traumatic stress disorder is only going to get them so far. They really, for a mental health defense, they really need to be able to prove that at the time he committed these actions, he could not appreciate the difference between right and wrong, and therefore could not appreciate the wrongfulness of his conduct.
Now take me through the consequences. If he's found guilty on these murder charges, what happens next?
20 to life, and I don't think he's getting any chance of parole.
Okay, so we're going to go back to the defense's opening arguments, and then we'll come back and talk a little bit more about the nuances of this case.
And what you will also hear in terms of Mr. Woodward's prior statements to the police, prior testimony, and we anticipate testimony sometime during this trial. You'll hear him say that the first thing that he sees as he's come across is he sees Roger McCord there with a couple of other younger people. And one of the things you will hear is that Mr. Woodward's particular mindset is women and children are non-combatants. Adult males are the combatants in this situation. And yes, he does use language. He believes that he is in a wartime setting. He is in a combat mode. And how he addresses this is consistent with his prior training and his stealth mode and all of this type of thing. And he uses some pretty specific language, in terms of what his mindset was. But he will tell you, as he approaches that, he sees Roger McCord, 280 pound Roger McCord, and Roger McCord's got a baseball bat in his hand. And he believes, at that point in time, based on what he's heard, that Roger McCord is leading the charge to his house. And that they're encouraging all of the people, even the people that he actually considers non-combatants, to kind of join in the mob attack of his house. The burning of his house. They've already demonstrated clearly their willingness to burn various things at various times. And as I said, the most outrageous one was they were burning the sheet and shouting insults and threats toward his family. So again, there's no doubt in his mind that what he is looking at, possibly directed at his family, would be aggravated assault, which is a forcible felony, possible aggravated battery, that's hitting, touching, striking with a weapon, Roger McCord. He's already heard the gunshots, so he believes that one or more of these people may be armed. He's already heard the threats to beat him, specifically to death, if they can get him out of his house. So again, he's worried about those things. He's worried about arson because of their burning different things. Now, while he does not articulate it, if you look to the list of the statutory things that someone is justified in using deadly force to prevent, as lawyers, we understand that the forcible felony, which is most apparent and is actually being committed virtually from 9 o'clock all the way to 12:40, is aggravated stalking. It is a forcible felony under the law. If you follow the law, a person is entitled to use deadly force, and the law makes no distinction between one gunshot or 31 in terms of deadly force. You can use that to prevent the commission of aggravated stalking. So there's a legal justification for his actions well before he acts. But Mr. Woodward, the evidence will show, waited until he felt that the threat against his family was imminent. And that's when he acted. So he rounds the corner, he sees Roger McCord, this giant of a man with a baseball bat in his hand, heading toward his property, and he shoots him in the head. And a couple of seconds later, you hear the second shot. Now keep in mind, there's going to be some conflicts in the testimony in terms of the sequence of shot or who shot one. Listen very closely to the gunshot pattern, because I suggest to you that that will show what the sequence is. And Roger McCord is shot twice in the head. And then there's a pause. And at this point in time, the person who is shot is Tim Blake. Bruce Tim Blake. The reason that we use Tim is because if you hear names and hear different things, Tim is what he typically went through. Bruce Timothy Blake is his correct name. And throughout this trial, you may hear him referred to as Bruce Blake or Tim Blake, or Mr. Blake. But that's the person. And he's the person who was shot and survived. And you will hear from the evidence that Mr. Woodward, seeing him and seeing him in the shadows, saw him and believed that he may be armed, believed that he may be the person with the firearm. And he essentially emptied his clip into it. You hear 13 shots in rapid fire. Bang, 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 bang. Okay? And Mr. Blake went down, and Mr. Woodward thought he was dead. That's what he told the police later. And at that point, because he still has all of these different people, keep in mind, he's one against many at this point. And people are running around. And people are going and running and hiding and shouting and screaming. And you hear a lot of that as well. But he puts in the second clip. And then Gary Hembry comes out of his house. And it's unclear from Mr. Woodward's perspective. He had sensed, he had actually, when Mr. Blake hit the ground, he had seen, at that point in time, I believe the evidence from his testimony is that he was looking for the gun that he believed Mr. Blake had, because he wanted to make sure that that was not accessible to anybody else. And he came to the realization that what he thought was the gun was actually a metal cup or mug type thing. That's what he had seen and believed to be the gun. So at that point, he came to the realization that Mr. Blake did not have a weapon. And he sees Mr. Hembry come out, clear. He sees Mr. Hembry reaching as if to have a weapon, and he shoots him. Again, multiple times, and basically empties a second clip. Because under the stress and the adrenaline and everything else, he just keeps firing until the gun is empty. At that point in time, he recognizes that the gun is empty. He does tell the police that if he had had more bullets, he would have made sure that Mr. Blake was indeed deceased because he wanted to eliminate the threat. And he had believed at that point in time, my words, not his, that he had cut the head off the stake of the mob. And he walks back to his home. And as he walks back to his home, one of his other neighbors calls out to him and says, Billy, Billy, are you all right? And he calls out, yes, I'm all right. I got them all. You'll hear that on his face. And he goes and he kneels in his driveway, puts firearm, now empty, in front of him, he put his hands above his head. Because he knows from his father's experience, stories and things like that, when the police arrive, he wants to be in a non-threatening situation. And at this point, he's almost preternaturally calm, given the situation. Because as he expresses, as the police comes up, the war is over. He tells them that he had to act, that his family would have been in body bags, that he had not. And you hear various different conversations as they take him into custody and take him away. The evidence will show that a little later on that evening, Mr. Woodward consented to an interview by a female officer at the Titusville Police Department, where he explains what he and his family had been going through, what his thought process was, why he felt he was compelled to act, and what he did. And you'll get to see, because this is a video recorded interview, you can see the range of emotions that can go through that. And he explains to that officer, why he chose not to take out any of the people that he considered innocents or collateral damage, that it was part of his life experience, his training, that women, you'll hear him talk in very strong terms about Carrie Blake and his disdain, almost hate for her and what she had done and threatened and done in his family. But in the same breath, he's talking about, but, why didn't you shoot her? She's a woman. She's not a threat. I only eliminated the threat. That's his mindset. The younger people, even though they were participating in these acts that were threats against his family, they were off the table in terms of combatants in his mind. So he didn't deal with them. At the end of the evidence, and there's going to be a lot more things. There's going to be some things when we're talking about, he concedes that he learned that after he shot them that they were unarmed. But keep in mind, unarmed at that moment in time does not mean capable of being armed and still being a threat to him in the situation. Because you're going to see some photographs that show different things that certainly are accessible to this mob in terms of weaponry. One of the most impressive is something that Tim Blake created, which he calls a shark killer. Apparently he uses this chain and ball with these spikes on it to bludgeon sharks to death. And that's hanging off the grill there. And there's different points in time in the photographs you can see sharpened pipes and things like that that have been sharpened to almost spears. And we learned after the fact that Roger McCord had a folding knife in his possession that kind of fell out of his pocket while they were taking him to the hospital things. And again, just the guns. Some point in time, gunshots, what I would suggest to you, clearly are gunshots. There's distinctive here. To talk about the bombs, to talk about the other things. There's plenty of reason for a reasonable person to conclude that any member of this mob had the apparent ability to carry out their threats, certainly had the ability to carry out their threats to beat him to death, certainly had the capability and demonstrated the capability to burn his family home as they slept. And if you hear the gunshots, certainly had the capability to engage in a gunfight. At the end of all of this, the decision, I think the evidence is going to be absolutely clear that Mr. Woodward was acting in what he believed was defense of himself and family. Part of the decisions you're going to have to make is whether or not he used excessive force. Again, we believe the evidence will clearly show that he did not, based on what he believed. But even if he did use excessive force, that would be a manslaughter. That there is no premeditation. In fact, the very things that the state is using, the evidence will show, as evidence of premeditation are actually the fact that he held back and did not react in anger or revenge or to the taunting. He waited until he believed that the threat was imminent. The very thing that the statute requires him to do. And we believe at the end of the case, it will clearly show that while he had every reason to have ill will and an emotional response to what had been directed toward him and his family over a period of months, that when you hear his explanation to law enforcement the night of the event, it will be clear that that is not what he was acting out of. So it's not second-degree murder. It's not premeditated murder. It's not second-degree murder. It's not even really manslaughter because his act.
And welcome back to the Law and Crime Network. I'm your host, Amy Dash, here with Law and Crime trial analyst Ken Belkin. You were just about to say something here. You don't like the defense very much.
It's not, look, I love the defense. I'm a defense attorney by trade and practice. But I got to say, listening to this defense argument, it sounds so contrived.
Why?
When you listen to the testimony of the detective in this case. He didn't talk about being afraid the night he was arrested. He talked about being at war, dispatching the enemy, that tonight he finally snapped and he went off the deep end.
I was going to ask you about that because that stood out to me. He told the detective, tonight I snapped, exactly what you said, and I went off the deep end. What does that tell the jury about his psychological state?
These are statements that are given shortly after the incident, pretty much contemporaneously with the incident. So really, it's his freshest expression of how he felt. And he didn't, he didn't convey any feelings of fear of imminent threat. This is all after the fact.
Well, he did say, I was tired of living in fear to the detectives. He
tired of the bullying and harassment, tired of living in fear. There was no talk of an imminent threat. He didn't feel that his life was in danger at the time. This is contrived after the fact. This is the skillful work of a defense attorney that's trying to, take a square block and put it in a round hole.
But will the jury see through it?
I think they will. I mean, I wouldn't underestimate a Florida juror.
Why is that?
I just think juries, first of all, they're comprised of a broad, cutting of society, and I think there's going to be people on the jury that are going to be like, get out of here. This guy, there was no imminent threat. He went home. He had time to prepare.
Right. Well, the defense attorney was actually saying he didn't shoot to kill when he was experiencing this taunting, all these threats. He waited until there was an imminent threat. But couldn't you also reverse that argument?
Waited until there was a better opportunity to hunt these guys down like animals and take them out. Not waited for the imminent threat. Come on, you don't wait for an imminent threat. An imminent threat is either present or it's not.
Right, so he's trying to make the argument that at the moment that he went out to kill them, the imminent threat existed then. It didn't exist in the weeks prior to that. But you could also make the reverse argument that there was no imminent threat, and he waited because he had had enough. He was fed up.
Imminent implies there's an immediacy to the threat, and I don't see any sort of immediacy here in this situation. Now look,
well, because what changed?
I'm no fan of stand your ground laws anyway, but I gotta say, even given the state of the stand your ground laws in Florida, I don't think this fact pattern falls into it.
Yeah, and you were saying that Florida, we know that the system in Florida has had a lot of problems in the past.
Well, look, I don't
extremely tough on juveniles, by the way. I've covered stories involving juveniles that were, this one guy, Ryan Hawley, was put in prison, life without parole, just for lending his car keys to his friends who went out and committed a crime while he slept.
Which is now unconstitutional, by the way. But, you know, look, besides the fact that there are differences among the states, and look, Florida does tend to be a little bit more punitive when it comes time to sentencing and charging. They're just a little bit more strict than some other states for whatever reason.
But you said there are also advantages for defense attorneys
that
can benefit the defendant.
Even though Florida might be a little bit more strict in some sense, their criminal discovery rules are much more lax than some of the more, you know, what we perceive as more lenient states, such as New York. In Florida, you're entitled to all sorts of evidence way in advance of trial, way before a grand jury proceeding. You're entitled to depose witnesses in criminal cases, meaning that you can interview them under oath and get a recorded transcript of it prior to the trial, which is such a powerful tool. Any trial attorney will tell you the ability to question a witness under oath prior to trial is one of the best ways to get material out of that witness that will impeach their credibility on trial. People's memories are fickle. You know, you do a deposition and then a year later you do a trial and you're asked the same questions, your answers might change. And a skillful trial attorney will bring attention to those changes in answers and try to say, look, his story's changing, he's not reliable or consistent, you can't believe his testimony.
Speaking of which, there was a stand your ground hearing. And in fact, the defense tried to make the testimony of some of the witnesses, including the man who survived and his girlfriend and some other people, admissible during this trial exactly for that reason, because he wanted to use those prior inconsistent statements to try to impeach those witnesses.
Yeah, prior inconsistent statements. It's the best tool a trial attorney has, really.
What do you think the jury will make of the fact that this guy employed his own surveillance system? Because if you're going to go shoot and kill people, wouldn't you not want to have all the stuff filmed?
Yeah.
I mean,
you're doing a lot of the prosecution's work for them by surveilling yourself while committing a murder and two murders and an attempted murder.
Yeah.
So, you know, kudos to Mr. Billy Woodward.
So what do you think? Do you think the defense really has a shot at all at overcoming these murder charges?
I don't think so. I think he's going down. And I hate, you know, despite the stand your ground defense, which is, you know, it's being put forward by his defense attorney as capably as can be possible, but it's just not going to stick. I don't see it sticking. I would be very surprised.
Now, what about the fact that he could face the death penalty if he's convicted? So what will factor into the jury's determination as to whether to apply that to this case?
There's going to be aggravating factors, you know, premeditation, the heinousness of the acts. I do think that he will probably not get the death penalty because there are mitigating factors here. This man served bravely in wartime in 1991 in the first Iraq War, the Persian Gulf conflict. He suffered from PTSD. He had been consistently harassed and intimidated by these people to the point that he snapped. And I think the court is going to look at those as mitigating factors, and they're going to show some leniency on him, and I do not think he's going to get the death penalty.
So you think that the jury might be sympathetic to the fact that not only was he a veteran, but he had people antagonizing him when he was suffering from post-traumatic stress disorder?
I think it's a mitigating factor in this case. And the fact that he served in our military, you know, very bravely during wartime, that should be factored in. The fact that as a result of his service, he suffers from post-traumatic stress disorder, that should be factored in. And the egregious and harassing conduct of the three victims, really, should also be factored in. These were not three totally blameless people. They had antagonized this man. It wasn't like this guy all of a sudden woke up one morning and said, I'm going to kill my three neighbors where they stand in their carports.
In their carports, oh Lord. And it's very sad because at the end of the day, lives were lost, but by the same token, like you're saying, this wasn't somebody antagonizing someone in the heat of the moment during one argument. This was going on for months.
Yeah, it was going on.
It was building. And there were intense threats here about harming people that he loved and burning his house down with his whole family.
Burning his house down, committing sexual assault against his daughter.
Right.
These are egregious things. These are things that might make me snap.
I mean, they don't justify death, of course.
They don't justify it, but it is something that it's not like this guy just acted in such a heinous fashion. He woke up one day and he said, I just don't like the looks of these guys, and I'm going to take them out. And
obviously it was pretty miraculous that that man who was shot 11 times survived. So right now I just want to toss to a clip of the crime scene technician and the responders who came upon this man as he unveiled who committed these killings.
Photograph.
Yes.
Were you the person that took that photograph?
I don't remember if I was the one that took this photograph or not.
You recognize the scene depicted
Yes.
in the photograph. Does that fairly and accurately depict the scene on the night of September 2nd through September, early morning hours, September 3rd?
Yes.
Okay. And can you briefly describe to the jury what the area of that scene this photograph depicts?
This photograph is showing a portion of the carport in 1940 Smith Drive. There is what appears to be a round kitchen-like table with some chairs and objects on the table.
Okay. And 1940, do you know what one of who's associated with living in that house, I guess?
I don't recall.
You don't recall. Okay. I would offer.
Any objection?
No objection.
Without objection, N will be number 4 in evidence for defense.
Now we're back to the O for identification. First of all, do you recognize what's depicted in that particular photograph?
Yes.
Were you present when those items were taken out of Mr. Hembry's pockets and arranged for that photograph?
Yes.
And who did that, actually?
The medical examiner, the forensic investigator from the medical examiner's office.
Okay. But you were present and observed him doing that?
Yes.
And do that photograph fairly and accurately depict the contents of Mr. Hembry's pockets in the early morning hours of September 3rd, 2012?
Yes.
I would seek to introduce that as my next number.
Any objection? Without objection, defense O will be number 5 in evidence.
Thank you. That's all the questions.
And welcome back to the Law and Crime Network. I'm your host, Amy Dash, here with Law and Crime trial analyst Kenneth Belkin, who is also a criminal defense attorney in New York City and drives his own car around New York City.
And I do it without the aid of a carport. And I don't say this to disparage people with a carport. I'm actually quite envious because my car is parked outside my apartment in Brooklyn and gets broken into 5 times a year and pooped on 300
I think you're
days
trying
a
to
year.
compensate for the embarrassing fact that you didn't know what a carport was.
I knew what a carport was.
So now you're trying to win over the
Dash.
favor of people across the country who have and appreciate carports.
I appreciate them. I just don't have them.
You know
I wish
what?
I did.
We're not going to judge you today. We have someone else on trial, Billy Woodward, who is charged with first-degree premeditated murder with a firearm for the killing of 2 people and attempted first-degree premeditated murder with a firearm for the attempted killing of Tim Blake, who survived miraculously after being shot 11 times. When we talk about the state seeking the death penalty for this case, we were just talking about some of the aggravating and mitigating factors. How will the defense try to establish that this man should receive some sympathy from the jury because of his experience in the war? What are some ways that they can get an advantage? Who do they need to bring in, and who should the jury hear from, you think, that would be compelling to that cause?
I mean, I would seek to bring in other people he served with in combat operations.
Because they have credibility, right? Other veterans?
Yeah, a veteran, superior officers, anyone that could attest to the nature of his service. I would try to get a copy of his discharge papers, if they were honorable or dishonorable, to show, he served honorably. Present that to the jury. I would try to get, mental health professionals to testify to the fact, and this is all, after he's convicted. This is for his sentencing. I would try to get mental health professionals to talk about the post-traumatic stress disorder that he suffered from, and I would try to introduce, the evidence of all the harassment, the video and audio surveillance, all of these terrible things that these 3 victims said and did. And look, it's not an excuse, but maybe, just maybe, it would save this guy from the death penalty.
With the death penalty on the table, why do you think that the defense attorney didn't encourage this man to take a plea deal when you have a survivor who is going to testify and say, he shot me 11 times and I saw him kill my friends here?
Well, look, sometimes it's your client's choice. You can influence them, you can guide them, you can advise them from the benefit of your experience as an attorney. But at the end of the day, the ultimate objective in any case, it is the client's decision, and they are the ones that have to make the decision. And for whatever reason, this defense attorney was not able to convince him to take a plea deal, and this guy insisted on going to trial. Maybe he was so steadfast in the belief that he was justified in taking Mr. Hembry's and Mr. Pissior's lives. I don't know. But for whatever reason, he chose to have his day in court and be tried by a jury of his peers, as is his right under our Constitution.
Now, you said that if it were you, you perhaps would have gone down the route of trying to bring up the insanity defense.
Yeah,
How would this, if it went that way, how would this case be tried on that defense?
I think if it were my case and I couldn't work out a plea deal that took the death penalty off the table, or maybe a little bit of a reduced sentence or what have you, I would have tried a mental health defense. If this had to go to trial, I think a mental health defense would have been the best way to go.
But when you talk about somebody not knowing the difference between right and wrong, which is usually the legal standard in most states, right? Yeah. I mean, some states have additional factors.
Yeah.
But like you said, he's preparing. He's clothing himself in these battle armor.
Preparing. But that premeditation, that deliberation, that doesn't mean that he's not suffering from some very real mental health disease or defect. He really seemed to believe he was at war with these people. This is a guy who has fought in wartime situations. And in a wartime situation, the usual right and wrong dichotomy, it gets a little bit blurred. In regular civil society, it is generally frowned upon and considered a very wrong thing to take an automatic weapon and open fire on a group of people. In a wartime, that's what you're expected to do as a soldier. And I think he was operating to some extent under the belief that he was at war with these people, and he couldn't appreciate the difference between right and wrong.
But then, of course, the prosecution's going to argue he didn't really think he was at war. He was just using this terminology because it's familiar to him.
Well, he also really didn't think he was under some sort of imminent threat, but it's not stopping the defense attorney in this case from going forward with that cockamamie defense. Which, by the way, I think you should probably try both of them. See what sticks.
Yeah, but you also have him, like you said, taping the incidents, going through the legal system on other occasions. So it seems like he knows what to try to do to protect himself.
I think there's a good chance he's not going to get the death penalty. Aside from the mitigating factors, look, it's got to be unanimous in the state of Florida to put this man to death. All they need is one juror. They just got to convince one juror that this man's life is worthwhile saving, and that society is better served and he is better punished by serving a lifetime sentence in jail.
What do you think of that unanimous requirement? Because it's from the Supreme Court. That's what makes it constitutional, right? Because in some states we used to have judges determining whether somebody should be sentenced to death until that was challenged, and it said no, it has to go to a jury and it has to be unanimous.
Look, I mean, I have some serious misgivings about the death penalty. I think historically in the United States, it's been applied. There's been a huge racial disparity in its application in the United States. Black people seem to get sentenced to death way more frequently than white people in most states, and I think that's a huge problem. And my belief is that we probably shouldn't even have the death penalty, not because there aren't crimes that are worthy of the death penalty. There certainly are, but because it's a very final solution, and we learned years later very often that some people convicted were wrongfully convicted, and you can't take that back. You can't give someone their life back once you've taken it.
Right, but a lot of times if a child, a baby is killed, or an elderly person, when you have vulnerable victims, sometimes people feel more justified, obviously, imposing the death penalty.
Yeah, I mean, look, there have been some legal scholars that have argued for an amplified standard when it comes to the death penalty, not proof beyond a reasonable doubt, but proof
like
beyond a shadow of a doubt.
Right, but like you said, there are aggravating factors. So if you have a particularly heinous crime, or you have the victim suffering, and these are things that might compel jurors to be more likely to
just think that the standard of the burden of proof should be a little bit higher in death penalty cases. Beyond a reasonable doubt, it's a little bit muddy, and we've convicted many people beyond a reasonable doubt that turned out to be innocent, 10, 20 years later.
Yeah, but I think a lot of times with those types of convictions, that's because the law is being misapplied a lot of the time.
Or
you have
the
largely
investigation was compromised,
right.
Evidence was tampered with.
Right.
We had a huge problem in Brooklyn, and the current district attorney is addressing it right now, and his predecessor, Kenneth Thompson, addressed it. They had a wrongful conviction unit that was overturning convictions from 20 years ago. People that went to jail, they were convicted, and for 20 years they stayed in jail. Now look, someone get 20 years in jail and they get out, they can sue the city, they can be compensated for that time, but if you take someone's life, you can't give it back. It's too final.
Right.
And that's why I think there should be a higher standard.
And that's why a lot of people are for an eye and the death penalty, even though you're not. But for first-degree premeditated murder, which is the charge here, just tell me, what does the prosecution have to prove here?
I mean, they got to prove that there's some premeditation, there's been some deliberation, which I think there is. This guy prepared, he put on combat fatigues, he did a whole little shimmy across his lawn as if he was in the jungles of Vietnam or whatever. And he took aim, he lied in wait, and he executed these people. This was not something that occurred.
But why is that
in the heat of the
relevant, Ken? Why is the way that he committed the killings relevant if he's not bringing the insanity defense? And we're not trying to prove that he thought he was in a war zone. Why is it relevant that he, may have ducked behind some bushes and he might have had some fatigues on, and maybe when he was shooting, he was getting himself all amped up?
It shows that this guy prepared. It shows that this guy was not acting under some sort of crazy pressure or in the heat of the moment where maybe he didn't have all his faculties available to him. It showed that he was a little bit cold and calculating in his preparation.
Why? Because he employed his training, though? Why?
Well, he employed... We want to punish more that person who takes a life with real cold and calculating, preparation than someone who just let's say, walks in on his wife sleeping with the milkman and goes for the gun and takes shot. It's worse when the guy, looks at the milkman, he has time to cool off, he goes and finds out where the milkman lives. He stalks the milkman out in his carport or wherever the milkman parks his milk truck.
But you know what? Sometimes you can still make a case for heat of the moment, crime of passion in those cases.
I mean,
even
certainly
when somebody
this guy
goes
had time to cool off. He had time to go home, put on his neatly folded fatigues. Maybe he washed the fatigues first. I don't know. But he certainly had time to prepare and to chill out and maybe watch his favorite episode of a TV program with a Budweiser before he did this.
Okay, so now let's listen. Thank you, Ken, for that very colorful analysis. Let's listen now to Officer Brian Nelson, and then I'll come back with Ken and we'll talk some more about all the issues in this case.
Who do you work for? I work for the Titusville Police Department.
And back in August or September of 2012, who did you work for?
I was still working for the Titusville Police Department.
And at that point in time, were you familiar with the Hembrys, the Pecors, the Blakes, and the Woodwards?
I was.
And how are you familiar with them?
Reference calls for service.
And how many times were you called out to Smith Drive regarding those individuals?
Calls specifically or pre-planned calls?
Calls relating to incidents.
I would say probably around 20.
And regarding those incidents, did you ever collect any surveillance or video footage?
I did not.
Did you ever arrest anyone relating to those incidents?
I did not make a physical arrest.
Did you ever pass on the information that you learned from these incidents to your hire at Titusville Police Department?
I did.
Do you know if Titusville Police Department ever took any action on that information?
I believe they did.
And what was that action?
I'm sorry, I didn't hear your response, sir.
I believe they did. I'm sorry.
And what was that action?
We had pre-planned, pre-generated calls doing property checks, which is basically an area check of that location to make sure the neighbors were staying civil with each other.
And were you ever instructed by a superior to contact the state attorney's office regarding to try to mediate the dispute that was going on at that location?
I do not recall that.
Have a moment, Your Honor. I have nothing further.
Cross-examination? The attorneys may approach.
How are you?
Doing well, how are you?
I'm good. You had an occasion to respond to this particular area on August 5th, 2012, isn't that right?
I did.
And that was a call for service that came out from the Hembry's house.
That was the second call for that day.
So you came out once before involving the theft from the porch, right?
That I did.
And you talked to both parties.
I did.
Okay. And then you left.
I did.
And then you received another call that the defendant, Mr. Woodward, was now in the streets trying to bait Mr. Hembry out to fight him.
That is correct.
And you responded?
I did.
Now, you said on direct examination that you didn't physically make an arrest. What do you mean by that?
We have different options as law enforcement. In that case, regarding the second incident on August 5th, I wrote a summons, which is basically, I wrote charges for Mr. Woodward and to be filed with the state attorney's office so they could review the case to proceed with the charges.
And that was done?
That was completed.
What the other incidents that you were called to respond to this particular area, every time you were called, did you respond?
Every time that I was called, yes, I did respond.
And do you recall any other specific instances that you responded?
The majority of incidents that I responded to were basically just verbal disturbances, which is basically arguing between the neighbors.
Both sides?
That is correct.
And each time you came out, you instructed both sides to
go their separate ways. They lived on the corner. They both lived at the corner houses on Smith Drive. So there was, I would just separate them and make sure that they remained in their property to avoid confrontation.
Let's talk about the capias you sent up to the state attorney's office. So now you arrived on scene and you spoke to all the witnesses.
That is correct.
And that was Gary Hembry. He was there.
That is correct.
Roger Pecor.
That is correct.
Kerry Blake.
I believe so.
You'll just give me just a couple seconds. A lady named Crystal Hale.
I believe so.
Kim Cast.
Yes, sir.
Spoke with, I think I said Bruce Blake, but if not.
Bruce Blake, yes, sir.
You spoke with Barbara Woodward.
I believe so.
You spoke with Jeffrey Scott Crow.
That is correct.
Spoke with Lydia Crow.
That is correct.
You spoke with William Woodward Sr.
That is correct.
Now, after interviewing those individuals, why did you not arrest Mr. Woodward?
There was a discrepancy within the statements, and based on that reason, and there was no physical evidence, Mr. Woodward was not carrying a firearm at the time of my contact, and the discrepancy within the statements, I couldn't.
And you say discrepancy within the statements. The discrepancy was between the Hembrys, the Pecors, and the Blakes, correct?
That is correct.
And the discrepancy was whether he had a firearm, what he did with the firearm.
There was one person that said that they believed that he had a firearm, but did not actually see it. Different descriptions of what the firearm they saw was.
Now, you sent that case up to the state attorney's office.
That is correct.
But they did not file, but you sent it up as an exhibition of a firearm.
That is correct.
And that means that somebody basically showed a firearm, correct?
That is correct.
but that is not the charge that was actually filed.
I'm not sure what the charge the state attorney's office had filed.
Well, was it in fact disorderly conduct?
I do not recall.
Are you familiar with the charge of disorderly conduct? Are you familiar with disorderly conduct?
Yes, sir, I am.
And that charge does not include a firearm, does it?
It does not.
Have a moment, Your Honor?
You may.
Are you aware if that charge was ever no prost dropped?
Are you asking if
I'm
the
talking
charge like
about
that
the
has been
disorderly conduct. Was that charge later dropped?
specifically for Mr. Woodward?
Yes.
I do not know that information.
Any cross-examination?
There was no discrepancy in the statements that Mr. Woodward was trying to fight Mr. Hembry, though, right?
I don't believe so.
No, nothing further.
Any other questions? Okay. Thank you very much, sir.
Yes, ma'am.
You may step down.
And welcome back to the Law and Crime Network. I'm your host, Amy Dash, here with Law and Crime trial analyst Ken Belkin. Ken, if this case were being tried anywhere but Florida, do you think there would be any evidence that he could use, that Woodward could use in his favor, that he can't use in Florida?
I don't think so. In fact, I think he's quite lucky that this case is being tried in Florida,
Yeah.
with the exception of the fact that Florida has a death penalty, which is a big problem at sentencing.
Yeah, a slight twist to the story.
But look, the fact that they have stand your ground laws, you know, that could be used in his favor. As I've said, you know, ad nauseum on the show, I don't think it's going to work out so well for him because I don't think he can really establish a stand your ground defense here. I think a more apt theory is that he didn't get the invite to Mr. Hembry's Labor Day cookout, and instead of taking it gracefully, acted out.
You're joking.
I think there's something to be said about that. He didn't. This wasn't just a normal day. This was Labor Day weekend. Gary Hembry had invited like the whole neighborhood over for a cookout.
So you're saying he's jealous that Gary Hembry is like barbecuing hot dogs and hamburgers.
I think that probably
on the
played
grill,
into it.
And he's at home, what, by himself?
He said, this guy's been harassing me, saying terrible things about my daughter, threatening to burn down my house. Now he's out there having a barbecue like a big man of the neighborhood. I'm going to put on my fatigues, crawl across my lawn, do a little shimmy, and take aim at these people who are celebrating Labor Day.
We don't know that he actually shimmied across the lawn.
No, he did. He shimmied across the lawn.
How do you know that he shimmied across the lawn?
It was reported that he shimmied, Amy.
Okay. Is that a move that is taught in tactical training courses?
Well, I don't know. My shimmy is probably not as good as Mr. Woodward's, but you know, he certainly shimmied in this case and took aim. He lied in wait. This is not going to go well for him.
So define lying in wait so people can understand what that means, because that's a critical point here that needs to be analyzed and assessed. It's part of the statute.
It's definitely part of the analysis that, you know, he committed this murder with some deliberation. You know, he laid down there, he took aim, tried to conceal himself with some camouflage fatigues, presumably, and, you know, took aim steadily, deliberately, and fired. This wasn't like he just, they said some stuff to him, they made some threats, and he came running over with a gun.
But here's the thing, our producer Kathy Russin just updated me, which is true. There is a fact that they were taunting him, they were yelling at him while having this party. So you may be true, and you may be right in the sense that, you know, maybe he felt, oh, why should those guys have fun?
Doesn't matter. Yelling at someone's not an imminent threat. I mean, I can yell at Aaron Keller till the cows come home, and if he takes out a gun and shoots me in the state of Florida, of course, where they have stand your ground, it's not an imminent threat. It's not an imminent threat to yell.
But the words are important. If you're making threatening words, if you're saying you're going to kill somebody, you're going to burn their house, and you're going to rape their daughter, in some states and in some cases, even in Florida, I'm sure,
it is certainly,
there could be an argument that...
not a good argument, I'll tell you that. And I don't mean...
But why?
Because look, it's not imminent. There's no immediacy. Just these general threats, oh, I'm going to burn your house down. And look, while these are terrible things to say, especially the stuff about his daughter, they're not immediate threats. They're not imminent.
Okay, then what if they say, I'm going to come over here
right now.
Well, but what if they say, I'm going to come over here right now and burn your house down and rape your daughter?
I mean, people can say all sorts of things. Until the threat looks imminent and real, he's not privileged to employ lethal force.
So you're saying that you need some sort of physical action? Is that a requirement of the statute?
You need some sort of steps that show that the threat is credible, other than, just him being crazy. And by the way, this isn't like he reacted immediately to the threats. He went in, he prepared, he put on his little battle wardrobe and loaded his gun and went out there and concealed himself and lied in wait for the perfect time to shoot.
Do you think that it'll be easier to get a conviction on the survivor, the attempted murder charge, because he wasn't one of the people that was necessarily directly harassing him, meaning the level of harassment from each person will be more justifiable to have shot somebody who is the ringleader of the stalking
I mean, I think they're getting...
versus somebody who was just there that day and got killed as a consequence?
I think they're getting a conviction on the basis of all three victims, the attempted murder and the two murders. The only question in my mind is that, will he get the death penalty? And I think there's a very strong chance that there are some mitigating factors that can be brought to light that will prevent him from being sentenced to death.
We're going to toss now to a clip from one of the neighbors, somebody who knew this man, so she can talk about what it was like to live next door to him and just give a little background on what he was like